You're listening to KLOK, San Jose, San Francisco, and Oakland, the largest and most powerful Desi radio station in America, a universal media access radio station.
And now, from the San Francisco Bay Area studios, KLOK proudly presents to you the prominent attorney Shah Peerally for the Shah Peerally Law Show, coming at you with over 50,000 watts of power. The Shah Peerally Law Show, where all your views matter.
Hello everybody. Assalamu alaikum, Sastikar, namaskar to all the listeners. This is attorney Shah Peerally today live from the KLK 1170 studio, and we are broadcasting live with Chris on the board, and today is Thursday, May 11th. So if you're listening to that show another day, that means it's recorded. So we will be opening the lines in a few minutes. The number to the studio is 408-912-5565. But before I start, I just wanted to let you know anything I'm telling you today is my opinion. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. The number to our law firm is 510-742-5887, 510-742-5887. The website to check, attorneyonair.com, attorneyonair.com. Before I start taking the calls, let me kind of go over things what are happening right now, which is hot, especially concerning our listeners. Number one, the visa bulletin for June is out, and of course, while not to a surprise, EB1 is retrogress again, second time probably since the past year. And just to let you know, EB1 rarely gets retrogress for India. And India, both India and China moves to January 2012. That means basically for those waiting for a green card, you got to wait a little bit more. We are hoping it will come back to normal probably next month or the month after. But until then, they will be stuck in getting their green card, those who have already applied for their adjustment of status. However, the good news is that luckily with President Obama, rule of Chart A and Chart B, we still have people. You will still be able to file your adjustment of status on your EB1 and wait on the processing. You can still file it. You will still be able to file it, but you won't get the green card until they process it. And the other thing that we wanted, and I know there are some callers on the phone, I just wanted to tell them, be patient a little bit. I wanted to cover some topics. Number two, RFEs, a bunch of RFEs are being issued to a lot of people, especially people will be getting RFEs on Supplement J, which is the AC21, and also the medical. So some people are thinking now the dates are getting current or might be current under EB2 or EB3. What I think is just because of the Supplement J, they are just issuing a kind of blanket RFE just to make sure they are updating their system and having people fill the Supplement J. And if you need help to do that, Supplement J is just more like a conformity of AC21. I talked about it last week. And number three, there are a lot of site visits going on to companies who have H-1B providers. And you better make sure that you're compliant on all the angles, including your public access files, including your employees. If there are any amendments, you're moving any employee, especially for consulting companies, make sure amendments are filed before you move the employees, etc. So be very careful. I just wanted to make those three announcements. Let me take one caller, Chris. This is Shah Peerally. You're live in here.
Hi, Shah. Thanks for taking my call, and thanks
welcome.
for the radio show. It really helps all of us. So I have a question with my wife's hedge fund stamping. So her employer has applied her hedge fund in level 1, basically. So and this would be her first stamping as on hedge fund. So we are thinking of visiting India in the month of July. So what do you suggest that, do you expect any issues with the stamping and stuff? So just wanted to check on that.
Well, unfortunately, it's very hard to tell. Depending on the company, is it a consulting company or is it a...
No, No,
AAT?
it's a firm. It's
Okay.
a company based out over here.
Okay. Well, I don't see there's a lot of panic and fear going on, and there are good reasons for that. But ultimately, most stamping are happening smoothly. So I don't see any reason there will be a problem. Right now, your wife is on H4, right? What visa is she on?
No, she's on H1. She's already on H1. She got her H1 in last October. So she's on H1,
Hmm.
but we didn't go to India for stamping. Previously, she was on H4.
Okay. Okay. Just make sure you bring check stubs, you bring a letter of employment,
Uh-huh.
and if you are going on H4, bring a petition for marriage certificate, and that's pretty much it. And you can go for the interview. I don't expect problems for especially direct clients unless the
Okay.
company is under investigation. So don't worry, just go. But if you want to kind of go over things with me in more details, just give me a call. We'll do a consultation at the office before you leave at 510-742-5887. But I don't anticipate any problem in her case unless the company is under investigation. Okay?
Okay. Sounds good.
Okay.
Thanks a lot.
Good luck
Thank you.
to you. You're welcome. Let me take another caller, Chris. This is Shah Peerally. You're live on air.
Hey, Shah Peerally. Thanks for taking the call. And,
You're
I have a
welcome.
quick question that, I'm moving my employment, I'm changing employer in this situation where, the employer couldn't able to file, in the premium processing before April 3rd. So, the employer
Mm.
filed, and then now I have to work on the receipt. So, is there any risk of getting approvals or anything later? And also, if I need to travel outside, what kind of precautions I should take care? I can take the call offline.
Okay. That's two good questions. Number one, working on the receipt is not risky because well, it is risky. I'll tell you how, but technically that's the law. Under AC 21 Section 105, you are technically allowed to work while the case is pending. That's the rule number one. Now, number two, what is the risk? Of course, is there is a risk of being denied, and by that time, since it will take 6 months to get approved, you won't even be able to move back to company A. Let's say you move to company B already. Now, the second issue, you asked the question, you have to travel. Don't travel while spending. You can't because the problem is that you don't have a solid status while while you have a transfer. What happens is your status almost liquefy keeping is in limbo while it's pending. So until you have a solid approval, I don't recommend you traveling. If you want to travel, then you might have to first travel and then do the transfer. And unfortunately, I cannot kind of go over things into too much details on the phone, but you can give me a call at the office. We can discuss 510-742-5887. Let me take another caller. This is Shah Peerally. You're live in here.
Hi, Mr. Shaw.
Hello.
How are you, sir?
I'm doing well, sir. I'm doing well. How about yourself?
Good, good. Thank you. I just want to ask you about my sister. She want to apply for a visiting visa since my brother, daughter, she's going to get married in August of this year.
Yeah. Yes.
So beside the application, what other good documents she needed to, to get the visiting visa?
Well, the visiting visa doesn't really have a list of documents. It's let's say for example she's coming for a wedding, then you can show the invitation card. If she's coming
Yes,
for a graduation, you can also yeah, you can show the stuff. But unfortunately, the visitor visa is not dependent on those. What it is dependent usually on is your ties under I-821-4B to India. She's from India, right? Where are you
No, from Pakistan.
From Pakistan.
Karachi.
Okay. So Karachi. So they will ask what ties she has to Karachi, and unfortunately, visitor visa is luck. Even you have all this, you can still get the. I've seen cases where people have the proof that they have ties to Pakistan or their country, and then they still get denied. I've people who went for the interview and they get it right away. They don't ask any questions. So Only thing if she has a job, for example, good to have a letter from the job that's stating how many days she got off. And also, people make mistake. They sometimes ask for visitor visa for 2 3 months. They won't. Right there, it's kind of raise a red flag because nobody comes for 2 3 months usually for vacation. So most of the time, up to like 5 weeks is reasonable. But sometimes people want a longer stay because they're paying the ticket expensive. So if she's coming for a short time, she has something like a job or a business or a property there in Pakistan. Bring those documents with her because that will help her. But there's no way really to tell if you can win it or not. I have a YouTube video on guidance on B1 B2 visa. I think if you just type on YouTube B1 B2 visa and you put my name, the video will pop up. Actually, if you type B1 B2, it will probably pop up because a lot of people watch this video. It will give you some tips what you can do. But unfortunately, that's why I don't do visitor visa. I don't prepare it for people because no matter how much you pay me, there's no way I can control it. So it's all your luck. What you can bring is everything show that she will go back to Pakistan. That's what they really want to know. If she's studying there, she has a husband there, she has children there.
She don't work. She's just a housewife, and she's over.
And where's her husband?
Husband, he recently passed away.
Oh, yeah, that's not going to be good. Unfortunately, because they might think she's just going and not coming back. But she can always try her luck, and if she shows all this and they believe her, they will let her in. Okay? Good luck to you. Okay?
Okay, thank you.
Thank you, sir. Thank you, Sam. Let me take another caller. This is Shah Peerally. You're live on air.
Hi. Somebody asked a question about joining another company with the receipt. So I have a follow-up question for that. So what happens if the visa gets rejected? So how many days one has to leave the country? So is it like 60 days, or do they have to leave it right away? Leave the country right away?
Well, that's a very good question because if you get terminated, you have 60 days. But they have not said anything about the rejection. Technically, the way it works is that you're supposed to leave right away, but as long as you leave before 180 days, you won't be affected by it. Okay, don't get me wrong here. Let me explain what I'm saying. What it says is basically as long as you are not accruing unlawful presence, because once it gets denied, you're starting to accrue what we call unlawful presence. That means you're becoming illegal. As long as you don't accumulate more than 180 days of it, when you go, let's say, for example, down the road, you find another company who did another kind of transfer for you and you get approved, at this time, they won't get approved as a transfer. They will get approved as what we call a new employment counselor processing. And when you go for stamping, then you will have to go for stamping or leave the country, come back to get your I-94. Then you need to make sure you're not passing 180 days. But that 180 days is not how to put it, it's not a grace period. It's not like you're legal here. Only thing is that you get forgiven when you have to reset the visa by leaving and coming back in. Okay?
I see. Thank you.
Okay? You're welcome. Let me take another caller. This is Shah Peerally. You're live in here.
Hello, sir. My name is Kiran. I have a question about...
Hi, Kiran.
Yes. So, I'm on H-1B. Currently, it's close to end of 50 year on H-1B status. So, recently, my current employer, through my current employer, I got 140 approved 3 months back. So, my question is, if I change a company now to the new employer, the old 140 will remain active? My current employer already agreed that he never revoke. But is there any other chances of USCIS if I apply through another H-1B filing with a new employer? Is the current 140 will be remain active, or just that question?
Okay. First of all, the I-140 cannot be cancelled if you pass 6 months. In your case, you say 3 months. So even the company say they won't revoke it, they have a right to do it. That's number one. If they don't, then no problem. You can use that for more extension down the road. Now, your question was if that present I-140 gets revoked and you get another one, then it doesn't matter. You still use the priority date. So the priority date will be there. That's the only thing you will be able to use anyway. The priority date. So that priority date doesn't go away even they revoke the H-1B unless it was revoked for fraud. That's different. Then,
so, continuation question actually. So, if worst case, if it gets revoked in the new employer, for the new employer, by end of 6th year, do I need to hold any valid 140 approved one, or just labor is completed is enough status to get the extension?
No, you need to have a new I-140 unless labor is pending for 365 days. But if you have another old I-140 still there, you can still use it for an extension.
Okay. Even with the new employer?
Okay. Yes, you can use that I-140 for extension with any employer as long as it's alive. But if you're relying just on an approved labor, it doesn't work. You can rely on a pending labor of 365 days or an approved I-140, not an approved labor. Okay?
Okay. Other than the employer, is the USCIS has the right to revoke my 140?
Yes. I-140 can be revoked for what we call willful misrepresentation of fraud. Let's say, for example, the I-140 was done based on a fraudulent job offer, or the company's under investigation, and they find out they just did that to help someone, or they find out that they didn't properly do the recruitment. Yes, they have a right to. This is a good question, because the truth is that only USCIS have a right to revoke an I-140. When an employer take away an I-140, it's not called a revocation. It's a withdrawal. It's kind of basically just saying, hey, I don't want this person, but it's not really a revocation. The revocation is done usually by USCIS, but we still use the word revoke, but that's not really the right word, okay?
Sir,
so withdrawal can be done by company. Yeah, go ahead.
Right now, I'm in the process of switching a new employer. As I said, 3 months back, I got 140. A month back, I applied a EAD, H4 EAD for my wife. If I change my new employer, the H4 EAD is still in progress status, or that will be cancelled for any reason?
It won't be cancelled if the transfer is done properly by the lawyer and an H4 also is filed together. So if the lawyer didn't do that, then once the H1 is cancelled by the previous employer, then the H4 of your wife will be gone and the EAD will be gone. Okay? So let me take another caller now. Good luck to you. This is Shah Peerally, you're live on air. Hello?
Hello?
Yes, sir. Go ahead.
Yeah, I have a question regarding the green card. My company is planning to apply the green card, and they are ready to file the form. I think that ETA 9089 form. I have a question.
Yes.
So they specified, the designation and the jobs and roles responsibility, right? So once they file it, is that tied only to the current company? Suppose in case in the future, if I want to change the company, and if my roles and responsibility changes, am I eligible to file a new green card? Or my basic question is, the existing one, is it anyway tied to my future job responsibility?
I think I got your question. Your question is basically, if you are shifting company and you have an I-140 approved with company A and certain job description or title, then you move to company B, they put you in a different job title. Are you eligible to file? Of course you are, provided you have the qualifications. Because one green card is not tied to the other. The only time it becomes tied up on what we call the AC-21 same or similar position is when you have an I-485 attached to it, 180 days have passed. Then if you're shifting the entire green card, you can only move to a same or similar position. But if it is just a matter of the I-140, it's not tied. You can still use the priority date also. So no, if that's your question, then you don't have any problem. Okay, as long as you have the qualification, you can go for it. Okay.
Okay, so I am eligible even to apply multiple I-140, right?
Yes, of course. But make sure you don't contradict yourself, okay? Because many times people ask me the same question. Oh, you told me I could file multiple of I-140, but now I'm getting RFEs and notice of intent to deny. But then when you look at their file, in one I-140, they put some kind of experience from company XXX, and when they come to the other I-1 labor, they put company ABC. then you're inconsistent. Then what they will say is that, hey, you're lying on one of them. So as long as you're consistent, you're fine. Okay?
Okay.
Right?
Okay. Thank you.
Okay, good luck to you. Let me take another caller, Chris. This is Shah Peerally. You're live in air.
Hey, I have one question. So, I'm planning to go to India for my H-1B stamping for the first time. But previously last year, I had to, I had a layoff at my job. And at that point of time, I have filed a petition. I have filed an application in USCIS to convert from my H-1B status to visitor visa status. But by the meantime, I already got another job, so they did transfer my H-1 and everything. So my question is will there be any concern since I have filed that visitor visa application in the USCIS at that point of time?
Okay. No, as long as it was filed genuinely and it was filed on time, no, it's not a problem. The way it works, if it is a genuine filing, that means basically you filed it on time and it was genuine. It doesn't affect your case. But if there was some kind of fraud, that's a different story. At this right now, the only thing is just you're fine right now. You should not be worried.
Okay, because at that time when I filed, they asked me for extra evidences and all those things. But by the meantime, I already got another job and my H1 was transferred, so I did not reply to them with anything additional. So
well, technically, should not. If you
okay.
did it properly and you didn't piggy right kind of on it, and they granted it, then it should not. But they can bring it back and ask you the question why you did that. But unfortunately, in that few minutes, I cannot really look at it and tell you if it is good or not. But I'm pretty sure if it was filed on a timely basis and there was nothing fraud there, you should be fine. They won't really make that a big issue. Okay?
All right. Okay. All right. Sure.
Okay.
Thanks.
Good luck to you. Yeah, give me a call if you want me to kind of look what you file. 510-742-5887. This is the number to our office and our website, attorneyonair.com. Let me take another caller, Chris. This is Shah Peerally. You're live in air.
Hi, Shah. Shah,
hi, sir.
Can we still accept the H1 receipts or it's all done? If you don't get today, that means we are not selected. Can we assume that?
If you have not received any receipt and your company or whoever issued the check has not been cashed, yes, because they had an announcement last week saying, I think last week it was, where they say it's the last day they already kind of did all the selection. So in short, yes, but you never know. The truth is, if the check, you have to double check if the check has been cashed. If the check has been cashed, then it doesn't matter you didn't give the receipt because it's probably been accepted. You just didn't get the receipt yet. Okay? So
to
ask
whom to check
your
whether the check is cash or not?
Employer. Whoever issued the check, if the employer issued the check or the lawyer who issued the check, they need to just go on their bank account and check if they cash the check. The filing fees. Okay?
So I need to check with the lawyer or the employer?
Well, I don't know who put the check. Who put the check? I'm pretty sure the employer put the check. So see with them if their check has been cashed. Okay?
Okay.
Okay. Good luck to you. Let me take another caller. This is Shah Peerally. You're live in here.
Hello, sir. Good morning.
Good morning, sir. How are you?
I have a question on H-1B extension using I-140. So I have I-140 approved from company A in 2011. And now I switched to company B. Can I use, and the company A is now acquired by some other company C. So can I still use I-140 to have H-1B extension?
The original company has been acquired by another company, and that company has an I-140, which you have, and you are asking if you can use it for extension, right?
Yeah, I have from company A. Now A is no longer exists. It's acquired by some other company C.
Okay. Well, technically yes, but it's very hard to answer like that because I have to see if there was a full successor in interest. But usually unless company A revoke the I-140, the I-140 is still good to get an H-1B extension, but it might be hard to use for what we call to get a green card. But for the extension, it might work. But unfortunately, it's very hard to tell because the rule goes under the if he's, whether it was a full success in interest. If not, then it might have some issues on the I-140. But to answer your question in short, most of the time, yes, you should not have any problem. But it's impossible to tell because we don't know what kind of agreement Company A had in the merger. Okay?
Okay, thank you.
You're welcome. Let me take another caller. This is Shah Peerally. You're live on air.
Hi, Shah. I have a question on citizenship. I applied for citizenship, in the end of Jan, and I had my biometrics done end of February this year. I wanted to know how long it takes for the citizenship interview from the biometrics.
Okay. Well, you said I didn't get the exact question, but you say how long to get the biometrics. The biometrics is coming around 6 weeks after the receipt.
No, I got the biometrics interview. Biometrics appointment is done. That was completed in end of February. I'm waiting for the interview.
Okay. Interview. Okay. Where are you located? Which area? In the San Francisco,
Fremont.
San Jose, Fremont. So you fall probably in the San Francisco. It's taking around 8 months right now for San Francisco. 6 months to 8 months. Okay. So so if you can from January to 8 months, around August you should get your interview or September. Okay?
Okay. Thank you.
Okay. Good luck to you. Let me take another caller, Chris. This is Shah Peerally. You're live on air.
Hi, Mr. Shah. My name is Ravi. Just a quick question on basically when we apply for a green card and get, let's say, a status of EB2, is there a way or a process to sort of move that into EB1? Because EB1 has this process of if you're in a managerial position handling global teams, then you can sort of move into EB1. But is that possible over the tenure of if you're already on EB2, can you move over to EB1 if that's the case?
You're talking about EB1C, right? EB1C, the managerial or executive. Well,
that's right.
It doesn't work this way. What the EB1C entails is very much like the L1A. You have to have worked for the foreign company in the past 3 years for 1 year, and then they transfer you back here under any managerial and executive power, and the business has been here for more than 1 year, or they transfer you on an L1A. But there's no real upgrade. It's just like you're filing EB1 if you qualify for it. The EB2 continues on itself. You just file for the EB1C. But that requires an assessment if you were there in the past 3 years for 1 year, and then they bring you back here on a managerial or executive capacity. If your question is to upgrade it, there's no upgrade really. You file it separately, but you have to qualify for it.
Sure, but what happens in cases wherein you sort of get promoted in the U.S. and now you become like a managerial position handling global teams? Isn't there a way to sort of upgrade the EB2 to EB1 because now you're at a position? But then the only caveat there will be that in the past year you're still in the U.S. and not in the offshore company.
In the past 3 years, where were you?
In the U.S.
Then it doesn't work.
Okay.
So you have to be physically there outside for 1 year in the past 3 years. So how can you be there and here? There is a very strict requirement on this legal presence, a physical presence, because I had clients which were short like 1 month. So they tried to use their time while they were sitting here that they were working there. It doesn't work. You have to be physically there. You have to accumulate 1 year in the past 3 years. Okay?
Sure. That's perfect. Thank you so much.
Okay. Good luck. Good luck to you. Let me take another caller, Chris. This is Shah Peerally. You're live in here.
Hi, Shah. Thanks for taking my call. I have a question.
You're welcome.
I am with employer A right now, and employer B has been transferred my H1. So the issue is employer A, when he applied for extension, he did mistake in entering my I-94. So he extended my old I-94 instead of the latest I-94 in as part of H1 extension. So, but it got approved, and now I see there is an issue, and employer B has been transferred with correct I-94, and it was approved. So, but my employer B has not yet started payroll. I am still with employer A. Employer B has not yet started payroll, so I'm still with employer A. So, I still have my I-94 for a month. So, even before extension. So.
Okay. Let me get it simple because I'm a little bit confused here. Basically, employer A filed an extension for you, but they filed it wrong. Employer B did a transfer, but the extension is good time, right? And you're moving to company B, right?
I have not yet moved, but I need to move. But I have a question like, as employer B has applied with I-94, correct I-94, now my I-94 got extended till another 2 years.
Okay, then if you go work for B, you don't have any problem, but you cannot continue working for A because they made a mistake. In 1 month, you have to already shift to B. That's all.
Okay.
Okay. So within 1 month, shift to B.
Sorry?
Employer A has to refile a new extension.
Okay.
Okay. Good luck to you. Let me take another caller. This is Shah Peerally. You're live on air.
Employer A has to refile a new extension.
Hello. Hello. Yes, sir. You're live on air. Go ahead. I'm listening to you.
Hi,
this is Shah.
I have a question regarding L1 to H1 transfer. So I came 2 years in 2008 on L1B, and in 2009 I got H1, but I didn't went on H1. I stayed on L1B, and in 2010 I changed to H1. So I've been getting extended since I've been doing the H1 extension from there on, and there was no problem. And this year I'm planning to go to India, so I need to go for a stamping. Will there be any issue since I didn't move from L1 to H1 after H1 got accepted?
Well, I'm a little bit confused. You say you already moved to H1 in 2010, right?
Yes.
Okay. So
but the
why
thing is,
what are you worried about?
I'm worried about when I came to US, I came on L1 and
Hello.
H1 from other company, not from the same company, but I still worked on the old company. But later on, I moved on to the new company. So my question is,
I got you. So the company that originally got you into the lottery, you never worked for them, right?
I didn't work for them for 2 years. After that, I started working with them. So they also filed my green card, and I got extensions. There was no problem.
After 2 years, then you joined them, right?
Correct.
Okay, and they had the H1 running at the same time, but you stayed on L1. And when you joined them, did you file anything, amendment or anything?
What is that? I didn't get you.
Okay, your case is a little bit complicated. I'll tell you why. When you did the L1, did you do a change of status, or you just did counselor processing when you moved from the L1 to the H1?
Change of status.
Okay. And then how did you stay on the L1 when the H1 was running? Did you move back to L1? You went outside and came back on L1 or something?
No.
Then you have a problem. You were not on L1 when the H1 kicked in. So 2 years, pretty much, you kind of violated the H1. So I would recommend that you give me a call or talk to your lawyer because there was a mistake there.
Okay.
It might come back or it might not. So just be careful. I will recommend talking to the company lawyer or give me a call at the office. We can discuss in more details because there might be some issues because technically what happened, you were already moved to H1 and you couldn't have continued working on L1 on the other side unless you have left the country, come back on L1. So you didn't leave in between, right?
Yes, I didn't left the company.
Okay. Well, definitely, you need to call me or talk to your lawyer. Give me a call at 510-742-5887. We need to have a consultation and make sure you probably made a mistake there. So we need to see how we can fix it. Okay?
Okay, thank you.
Okay, good luck to you. Let me take another caller, Chris. This is Shah Peerally, 11 here.
Hi, Shah. This is Manohar. I have a question regarding my wife's H4 EAD.
Yes. Go ahead.
So, her H4 EAD got approved, but there is a mistake, typo in date of birth. Only on EAD card there is a typo, but on I-76, not I-765, or H1 extension, there it is correct. So we call. So the question is, if there is a typo, can she continue with her employment, or will there be any problem?
Well, technically, she can continue her employment. The typo doesn't really affect it unless you made a mistake there. Even that, it's very hard to tell, but you're supposed to inform them.
It is not my mistake, actually.
Okay, but it was a mistake of yours. Yes. Well, technically, you can continue working, but they will ask you to return the other card and for you to get another one. So since it's just a date of birth, it might not be a big issue. She can just use the same EAD. But I would recommend fixing it as soon as possible, and she can use that card because the card is approved. It's just a mistake from the USCIS. So just go ahead, continue on the card, and then I need to look at where the mistake came from. So I have to look at your application and the card itself before I can give you a very sure answer. But since it is an immaterial mistake, as we call it, and especially it's coming from USCIS, it should not affect her to continue working. Okay?
Okay. Thank you so much.
Okay. Good luck to you. Before I take another caller, Chris, since we don't have a lot of time, I just wanted to discuss. Of course, we were talking in the beginning about issues of visibility and retrogressing for EB1, but that doesn't mean you should be discouraged to file your EB1 because Chart B is still good. And also, we discuss about RFEs coming a lot, and if you need help on those, we're pretty good at those. You can give us a call at 510-742-5887. The other topic, of course, I always discuss about is debt settlement because this is something that is kind of now becoming again hitting us because the economy is really acting where the dollar is falling, and there is a chance that we will be seeing some kind of crash in some market, but I'm hoping not. But in the meantime, people are getting laid off. So if you have issues with your credit cards or any debts, not every debt, but most debts, we can at least analyze it for you. We can help you get out of those debts. You can call us at 510-742-5887, and you can check the website yourdebtsettlementattorney.com. yourdebtsettlementattorney.com. The way it works is just negotiation. It's what we call pre-litigation. For example, you're $10,000 in a credit card and you're getting sued, or you owe them and they are bugging you. We can negotiate with them and get you a lower value, and ultimately you pay just maybe $2,000-3,000, and those are just fictitious amount I'm giving you. It might be less or more, and you end up by they write off the rest. I mean, more than write off, they clean it up. So these are called settlement. Write-offs are different in the jargon, but these are settlements. So we can help you, and you don't have to rely on bankruptcy to do that. And you can give us a call at 510-742-5887. Let me take another caller, Chris.
Hi.
Hello. Hi.
Yeah, hi. Yeah, hi, Shah.
Hi.
Morning. Thanks for taking
Good
my
morning,
call.
sir. Good morning. You're welcome.
Hi. I have a question for H4 EAD. Yeah, I'm on H1 with company A, and my firm processing is going on. And I have a I-140 approved from my previous company under EB2 category. So just wanted to know, I want to apply for my spouse H4 EAD. So how can it be done? Just wanted your opinion.
Okay, you can use the I-140 from the previous company, or if you have a beyond of 6 years extension to get your H4 EAD and basically claim that. You don't have to have an I-140 with the same company where you're working. As long as you have an I-140 or a 6 years extension already, you should be eligible. But if you're kind of confused how to do it, just give us a call. We can handle the case for you. We do a lot of H4 EAD. And H4 since we've been involved in this for a long time. So give us a call, we can help you. But you can always use an I-140 from another company to do that. And you can call my office at 510-742-5887 and we'll be glad to help. Okay?
Sure. I will touch base with you.
Okay. Good luck to you. So, ladies and gentlemen, I know it's I know we have some few more callers. So, since the time is kind of running on us, so I recommend that you give us a call at the office for a consultation at 510-742-5887. And if you don't want to do a consultation, you can always call next week from 10 to 11. And we were talking a little bit about debt settlement, so we can help you even in situations where basically you have a lawsuit against you, and we can negotiate those. We don't go fight it really in court because it's costly. What we do, we negotiate with the other attorney and make a deal with them, and we can help you on those. And you can give us a call at 510-742-5887. Now, the other things, the news of today, of course, is the visibility and retrogression. And this is a big news. Unfortunately, we are seeing a retrogression for India and China to 2012. And at the same time, we were discussing about of course supplement J and RFE. And finally, one thing which is really kind of bothering a lot of people, there are a lot of site visits, especially on consulting company and on companies, to make sure that they're compliant with H-1B rules for the employees. So we recommend that you keep good records of your H-1B employees, including your public access file. If you're moving your employer from one place to another, or you're doing a material change, you should file an amendment. Some people think, okay, we can file it later, but that can really backfire on you. File it before your employer moves to the other place. So make sure you do all this. And also, if you need help on anything when it comes to immigration, whether it's employment based, H-1B, L-1, EB-1, etc., you name it, you can give us a call at 510-742-5887. And also, I wanted to congratulate the team. We got a bunch of cases approved recently on EB-1, and EB-1s are tough cases. And so far, touch wood, we've been doing pretty good on them, and even on L1A. So feel free to reach out to us if you need help, 510-742-5887. And just to let you know, anything I'm telling you today is for educational purposes only. You should not act or refrain to act solely on the information provided. You should contact an attorney if you have any questions. The number to our law firm, 510-742-5887. I repeat that, 510-742-5887. The website to check, attorneyonair.com or peerallylaw.com. I wanted to thank you all for listening. This show will be rebroadcasting on Friday night, pretty much on 12 a.m. for Saturday morning, and you can listen to it. And of course, now if you need any help, give us a call. Thank you, Chris. We'll be back next Thursday, and I'll let Amit continue with the show.